Hi, students. We're still in Unit 2, Freedom of Speech. This is week 5, and it has to do with access to government property for the purpose of free speech. So, regarding free speech and access to government property, this will be a short lecture on this issue. It's not too complicated. But members of the public do not have an unrestricted right to use government property for speech activity. The U.S. Supreme Court has classified government property either as a public forum or a non-public forum. So we're dealing with two different types of government property here. When we talk about public forums, we're talking about two types of public forums. We're talking about, first of all, traditional public forum, our streets, sidewalks, and parks. So traditionally, they have been used by the public to get their message out. When you have a messaging and you want to get it out to the public, you go to places where the public are at. And typically that's the streets, the street corners, sidewalks, parks, and so forth. Probably they're I'd almost say they're not as used as much because of the internet, but I think still today uh, people do tend to use them to get their message out. There's also what we call designated public forums. A designated public forum is a forum that has been designated by the government for the purpose of free speech. So, for example, a municipal auditorium can be designated by the government to be used for free speech. Also, there might be a public meeting hall that's been designated for free speech. And also, at City College, there's a designated free speech area. I always ask my class where that is, and I get different answers. A lot of times people will, say the fountain. In the middle of campus, but that really is not the designated free speech area. The designated free speech area is that grassy area. It's in front of the cafeteria, extends out onto the lawn, um, into the area between the cafeteria and the bookstore. That is designated by the college as free as property that can be used for free speech activity by the students. So you have those areas. Now, even on campus, you still have the traditional free speech area, which are the streets, the sidewalks, any park within and on the city college campus there. So speech has maximum protection in these in a public forum, in the traditional public forums that I mentioned, streets, sidewalks, and parks, and also any designated public forum. Speech has maximum protection. People use them to reach larger groups of people. Now, the government can place reasonable restrictions on time, place, and manner. So they can have restrictions on this property, but the restriction has to meet three criteria. One, any restriction has to advance a significant government interest. So, what would be a government interest in restricting, say, people from using a street? Does the government have an interest, in other words, in keeping that street open to traffic? What about a sidewalk? Does the government have an interest in keeping the sidewalk clear so people can use the sidewalk to walk to and from businesses, into businesses to do their business activity? I would say yes to both of those, honestly. The government has a significant government interest to keep streets open to people so they can, drive and do their business. Maybe they're going to work, coming from work, to school, from school, shopping, taking kids, whatever. But they have an interest in keeping the streets open. So they could place a restriction on um, on that property. But the restriction also has to apply without regard to the content of the message. Remember, you can't touch the message. You know, the message is really what's going to be protected here. That's the speech part of it. The message will be protected, but the location where you're getting the message out may be restricted. So that's very important. Now, again, the message is protected unless it falls within one of those categories of unprotected areas of speech. Generally, you're not going to deal with what child porn. You're not going to deal with obscenity. You know, the other ones could apply: fighting words. Threats, but the biggest one would be incitement to immediate unlawful action. So incitement to riot, for example, you know, so generally the message can't be touched, but you have to really look at those exceptions that we talked about, because if those apply, then yes, law enforcement could do something about that. And then the third, you know, the government has to leave alternatives available to reach the desired audience. You just can't shut down the group and say, no, you cannot do that. You have to give them an alternative, you know, way to get their message out. So, for example, let's say, you know, you're the parent of a student, and the school has suspended the principal, or transferred the principal, for example. The principal is a well-liked individual. They don't give you any reason for the transfer. The parents are very upset about it. Their children are upset about it, and so they want to go protest this. So they show up at the school. They're in front of they're on the sidewalk in front of the school during school hours, and they have a someone with a like a bullhorn, and they're yelling and marching and, you know, blocking you know, the roads where the buses are dropping off students and picking them up. What do you think about that? Does the government have a significant interest in preventing that? Sure. You have a school. It's a government-owned property. It's not. It depends on where it's at too. The sidewalk would be a traditional public forum. The street would be a traditional public forum. So it has maximum protection at those particular locations. So, but the government has several government interests there. One is to keep the sidewalks clear so people can go to and from school, the streets clear so buses can go in and out of the school to pick up and drop off students. But the school itself has an interest in creating an environment where learning can take place. And so there's a significant government interest involved here. Um, any restriction has to be neutral as to the viewpoint. So you can't really touch the message. You can't tell them, hey, you cannot, uh, you know, say anything about this principle. No, that's attacking a message, and they can't do that. And then the restriction, you're going to have to leave alternatives available so they can reach the desired audience. Who's the desired audience? Usually it's going to be other parents that maybe um, haven't heard about this principle. So you want to leave other alternatives available. So what would you do? Well, you might tell them, well, you can stand on the sidewalk at this location. You have to do it before school, during lunch, or after school. Or if you're going to do it during school, you have to stand across the street. You can't block the sidewalk in front of the school. You can't block the street, so the buses can't get in and out. And also, because you're being so loud, you know, we don't want you interrupting the school environment. So if you stand across the street, and maybe you don't use that loud bullhorn or megahorn, then it won't interrupt a school. So you can place restrictions, but they have to meet those three criteria. There has to be a significant government interest. You cannot touch the message, and you have to have some sort of alternative that's available, so it permits them to get their message out to their intended audience there. So that is a public forum, pretty straightforward. What about a non-public forum? A non-public forum is still government property, but this is government property that generally is used by the government to conduct business activities. Does the government engage in business-like activities? Sure. For example, a post office. They're in the business of uh, taking in mail, delivering mail. That's what their business is. What about the Department of Motor Vehicles? They're engaged in registration and licensing of drivers. Military institutions, they operate a business. Courthouses, their business is resolving disputes in the court. So those types of businesses that are not what we call public forum, but they're still government owned and they're operating some sort of government business within them are considered to be what we call non-public forums. And a non-public forum has a different rule. The government may restrict access to their property, but the restriction must be neutral as to viewpoint. So what does that mean? You've heard that before. That means you simply cannot, again, you cannot attack the message unless, again, the message is one of those exceptions that we talked about earlier. But generally, you cannot attack that message. And then the second criteria for non-public forum is that the restriction, whatever the restriction is, has to be reasonable in light of use of the property. So the best case that you could read to understand this is the Krishna case. So what happened in Krishna? Krishna is a religious organization, and part of their religious beliefs is going into the public, soliciting money and handing out little information sheets about their religion. So that's what they do. And this case was generated out of New York. And the Krishna, they were aware of a regulation at the airport that prevented any group from going into the airport and stopping and soliciting any people inside the airport. So they were aware of this regulation. The Krishna actually wanted to have that, they wanted to challenge the regulation as being unconstitutional. And they wanted access to the airport so they can carry out their religious activity. So actually, before they went out to the airport, they actually filed a lawsuit challenging this regulation. So the court spent a lot of time just discussing what kind of business activity is being carried on at an airport. Now, first of all, you have to recognize that the airport is a non-public forum. It's not a traditional public forum like streets, sidewalks, and parks, and it's not a designated public forum for free speech activity. It is private, or that's not private, it's public government property, but it's being used to conduct a business, and the business is an airport where people are going to and from, catching a flight, flying out, flying in, and so forth. So they talked about the business of an airport, and then they talked about the restriction. The restriction itself said no person, no group can come into the airport to solicit any person within the airport. Now, was that a new point, a viewpoint neutral regulation? Yes, it did not talk about what about the message. It did not restrict any certain message. It was actually neutral as to the people. It did not target any particular religious group or any group whatsoever. It just said all groups cannot come in and solicit anybody. And why? Because it was a reasonable restriction. If they were to allow groups and individual groups to go into the airport to stop people, to solicit them for money and to hand out literature, what would be the effect of that on the airport itself? Well, you would create a traffic jam. People would be held up and stopped, and it would be hard to get into catch your flight, and hard if you were landing to get out of the airport if you allowed people to come into the airport to do those kind of things. So the Krishna is the best case because it teaches you that on a non-public forum, all the restriction has to be is viewpoint neutral, and it was, and it has to be reasonable in light of the use of the property. And in this particular case, the restriction was reasonable in light of the use of the property. I want to talk to you about two other things. One is private property. So private property, generally, the First Amendment free speech is not going to apply to on private property. So if a person attempts to engage in free speech activity on private property, the owner of the private property can ask them to leave. Now, we're in California, and there's going to be a difference in California, maybe even a difference in other states. But this goes back to the very first class, and I talked to you about the distribution of power when they created the Constitution. So remember, the colonials had the power, they had the state constitutions, and they gave some of the power to the federal government. So they didn't give all the power, but they gave some of the power to the federal government, and the government was supposed to be a government of limited power. And who held the rest of the power? The residual power, the police power, that was held by the states. So in California, when you're talking about access to private property for free speech, no, it's not permitted by the First Amendment. But in California, the California states, the courts, basically has said that our Constitution, the California State Constitution, under its California's police power, gives a person a right to engage in speech activity. It's not under the First Amendment. Don't confuse that. It is not under the First Amendment. It's under the state's police power. Under state power, they can go onto private property and engage in this kind of activity. This was in the Pruneyard case. It's a Pruneyard Shopping Center in San Jose. I've been there a long, long time ago. I don't know if it's there. It's an outdoor kind of a high-end shopping center, very similar to Fig Garden, if you've been to Fig Garden in Fresno. And this group of individuals, they were setting up a table. I don't know if they were soliciting, it was a voter registration, I believe, or some sort of sign-up sheet to protest something. But anyway, they were kind of out of the way. They were in public areas outside. They weren't blocking any sidewalks, very low key. They had a sign, they had the petitions there. And the security came by and said, kicked them off basically. And that's what led to the suit, and that this ended up in the state court, and the state court said, no, they have under the police power, the states have a right to, under the police power, to allow that activity on private property. It even went up to the U.S. Supreme Court, and the U.S. Supreme Court upheld it and said that the use of this police power to allow this kind of activity does not even violate the First Amendment. So crazy case, but in California, you can do that. Now, and there's another case that kind of followed the Pruneyard case, and this was an individual that was picketing at Six Flags Magic Mountain in Vallejo, California, over the treatment of dolphins, I believe. And he set up a table, and he was out of the way, but it was a table in front of where the public would go and buy their tickets and enter the park. And so the park filed a lawsuit to stop his activity, and it was granted. And then he filed an appeal, and the appellate court reversed. And basically, they were relying on the Pruneyard case, and they said, you know, he's in an area, although it's private property, it's equivalent to public property. It's out, you know, in a wide area. People are coming and going. He's out of the way. He's not doing anything. And so they relied on the Pruneyard case and said, under police power, the state can allow the free speech activity there. So that's what I just talked about was the access that people have to government property for speech activity. It's pretty simple. Think about it, read about it. run some examples through your mind, and I think it'll clear it up. Okay, if you're not clear about it, I want to talk to you about precision in making laws regulating speech. So when legislatures, either at federal level or state level, are going to make any kind of regulation, so for example, they've made regulations in California on criminal threats, right? So a criminal threat, remember the going back to the last week when we talked about you can't regulate the message, but there's those five categories, right? And one was making threats. Well, in California, there's a there's a criminal statute in the penal code 422 making criminal threats. Another exception is fighting or challenging to fight, fighting words, right? In California, there's a statute 415 of the penal code, which is fighting or challenging to fight, is a misdemeanor. Incitement to riot, there's also a penal code section in California for that. So child porn, there's um, an obscenity, there are statutes for those as well. So these are statutes that have defined that. So when the legislatures are going to are going to regulate speech through these statutes, it has to be very clear. It has to be very specific, very clear. Why? There's two reasons for that. One reason is it has to be clear to all of us because we are law-abiding people. We want to obey the law, but we have to know clearly what the law is so we can obey it. If it's not clear, then we don't know what is allowed and what's not allowed. And I'll give you an example of that. Back in the day, there used to be a crime called loitering. Well, what does loitering mean? That means standing outside with no purpose, apparently. But um, how long? Where are you standing? How long are you standing there? How do they determine that, right? So it's too vague, and that leads me to the other point. These regulations not only have to be clear for us, so we can obey the law, but they also have to be clear for a police officer who's going to enforce the law. So in that loitering violation, the officer is the one that's going to get to decide if you're violating that law or not. And I can tell you, if you have different officers, you're going to have different viewpoints as to what's lawful and what's unlawful. And frankly, you wouldn't even know what it is either. So those types of statutes are vague and they're unconstitutional. So these regulations that regarding speech have to be clear, and they have to be clear for us, and they have to also be clear. That was Israel popping in. They have to be clear for us, so we can obey the law, and they have to be clear for police officers because it gives guidance to the police officers so they know, um, when they can take action, when they can enforce the law, when they can make an arrest, and that is very important for all of us, right? So anyway, that wraps up this week. It also wraps up this unit. We're going to be getting into Unit 3 next. Unit 3 has to do with what? The authority to detain and arrest and the use of force. So we finished 2 units. Before you get into the unit, though, remember check your modules, follow that that schedule that's laid out there, and you do have a test. So there's a test that's on chapters 1 and 2. There is a study guide. Open it up, follow the study guide. Actually, I would print it out if you're able to do that, and make sure you go through every one of those on the study guide. And the answers are going to be found through my lectures and in the textbook. And if you can answer all those little points there, then you should do very well on the test. When you take the test, you'll notice it's true, false, multiple choice. There's 25 regular test questions and 5 extra credit. And you just take it right on line there, okay? So until then, stay safe, and I will be looking forward to the next unit. All right. Thanks a lot. See you later. Bye bye.